Mic check. All right, good morning and welcome to a regular meeting of the panel of utility commissioners and staff of the Public Utilities Regulatory Authority held today, October 28th, 2025 at 10 a.m. At 10 Franklin Square, New Britain, Connecticut in hearing room 1. My name's Tom Wheel and I'm the interim chairman of the authority. I'm joined today by my esteemed colleagues, Vice Chairman David Arconti, Commissioner Michael Karen, and Interim Commissioner Jan Beecher, who we're all excited to welcome on her first day at the authority. We have a regular calendar and a consent calendar on the agenda today. We'll first turn to the consent calendar, on which there are 9 items. Is there a motion on the consent calendar?
Mr. Chairman, I would move today's consent calendar items 1 through 9.
And I'll second.
Thank you. The consent calendar has been regularly moved and seconded. Are there any comments from the commissioners on the consent calendar?
No comments.
Mr. Chairman? How do I? Thank you. I'm in training. Mr. Chairman, as I joined the authority this morning, I have not had the time necessary to reasonably render a decision on the records in these cases. For this reason, I will abstain from today's vote.
Hearing no further comments, Mr. Bumpin, could you please take the roll?
My apologies. Was there a second?
Yes, I seconded.
Thank you. Chairman Wheel,
Yes.
Vice Chairman Arconti,
Yes.
Commissioner Karen.
Yes.
Thank you.
Thank you. The consent calendar has been adopted in full. Next, we're going to turn to the regular calendar, on which there are 2 items on today's agenda. The first is docket 250506, petition of Fuel Cell Energy for declaratory ruling regarding the applicability of gas system expansion rates pursuant to General Statute 1619 WW. And we will turn to authority staff to present the decision for the panel's consideration.
Yep. Good morning, Chairman Wheel, Vice Chairman Arconti, Commissioner Karen, and Commissioner Beecher. In this decision, the authority declines to issue the requested declaratory ruling. On May 1st, Fuel Cell Energy, Inc., or FCE, filed a petition requesting that the authority issue a declaratory ruling concerning the applicability of, quote, new rates set forth in General Statutes Section 16-19 WW, end quote, which are the system expansion or SE rates to certain customers. More specifically, FCE requested the following as a declaratory ruling: that SE rates shall apply only to new customers added pursuant to the system expansion plan, and as such, in accordance with the authority's April 27th, 2022 decision in docket number 210824, petition of William Tong, Attorney General of the State of Connecticut, and the Office of Consumer Counsel for an investigation into Eversource Energy regarding gas expansion marketing. Yankee Gas Services Company, doing business as Eversource Energy, cannot charge SE rates to FCE when FCE has neither signed up for the system expansion plan, has not executed a contract for service with Yankee, and is not an eligible customer as that term is defined in the docket 210824 decision. In 2013, the authority approved, among other things, SE rates for customers added to Yankees, Connecticut Natural Gas Corporation's, and the Southern Connecticut Gas Company's distribution systems pursuant to the system expansion plan to offset incremental costs of expanding natural gas infrastructure pursuant to the plan. On March 17th, 2020, the owner of the property on which FCE's facility is located signed a service agreement with Yankee for new rate 30 SE service at the property. Subsequently, Yankee installed mains and services to serve the facility as well as any other potential customers. On April 2022, the authority issued the docket number 210824 decision. In that decision, the authority ordered an immediate winding down of the system expansion plan by, among other things, ending the enrollment of new customers in the plan effective the date of the decision, with discrete exceptions allowed for those customers identified in the decision known as eligible customers. Any customer not identified in the docket number 210824 decision as an eligible customer, and any eligible customer who either did not enter into a service agreement or entered into a service agreement after the date certain, is ineligible to receive system expansion plan benefits. Yankee listed FCE's facility as one of Yankee's 13 projects with a signed agreement. On May 25th, 2024, FCE submitted a motion number 31 to the authority, seeking clarification regarding the applicability of SE rates to new customers. Specifically, FCE requested that the authority clarify whether property for which a contract for service between FCE and one of the gas companies was not fully executed prior to the date certain is subject to SE rates and eligible for system plan expansion plan benefits. In the ruling on motion number 31, the authority stated that clarification was not required as the issue at hand was already sufficiently clear. Further, the authority stated that if FCE's facility is not an eligible customer or is an eligible customer but did not execute a service agreement on or before the date certain, it is ineligible to receive system expansion plan benefits. Subsequently, FCE filed a second motion with the authority requesting clarification concerning the motion number 31 ruling. Specifically, FCE requested clarification as to whether Yankee can refuse to provide gas service to FCE's facility unless FCE executes a contract for service with Yankee at the SE rates. In its ruling on motion number 32, the authority again stated that clarification was not required as the issue at hand was sufficiently clear. FCE's facility is identified in the docket number 210824 decision as one of Yankee's 13 projects with a signed agreement and therefore is an eligible customer with a signed agreement. FCE's petition asks the same questions that the authority ruled on in the motion numbers 31 and 32 rulings. Consequently, for the reasons stated in the motion numbers 31 and 32 rulings, FCE's facility is an eligible customer as that term is defined in the docket number 210824 decision and is therefore subject to SE rates. Accordingly, the authority declines to issue the declaratory ruling requested by FCE. Thank you for your consideration.
Thank you, Attorney Keenan. Is there a motion?
Mr. Chair, move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. I will again ask if there are comments from any commissioners.
Mr. Chairman. Again, as I joined the authority this morning, I have not had the time necessary to reasonably render a decision on the record in this case. For this reason, I will abstain from today's vote.
Thank you. Hearing no further comments, Mr. Bumping, could you please take the roll?
Chairman Wheel,
Yes.
Vice Chairman Arconti,
Yes.
Commissioner Karen,
Yes.
Thank you. The decision has been adopted. The next item on the regular calendar is docket 241004, application of the United Illuminating Company to amend its rate schedule. And we will first turn to the authority staff to present the decision for the panel's consideration.
Thank you. Good morning, Chairman Wheel, Vice Chairman Arconti, Commissioner Karen, and Commissioner Beecher. Welcome to Pura. On November 12th, 2024, the United Illuminating Company filed an application with the Public Utilities Regulatory Authority to amend its existing rate schedules pursuant to General Statute Section 16-19. The company provides electricity service to over 341,000 residential, commercial, and industrial customers in 17 towns and cities in Connecticut. The company proposed a 27.4% or $105,418,797 increase to its currently authorized revenues of $384,865,000 for a total revenue requirement of $490,283,797. The company also proposed a 10.50% return on equity, which is a 140 basis point increase from its previously allowed 9.10% return on equity. The company subsequently filed a motion to adopt its alternative resolution position, which stated that a revenue increase of $63.7 million, or a total revenue requirement of approximately $448,565,000, is, quote, sufficient to enable the company to operate its business and continue providing excellent service to its customers in Connecticut, end quote. The authority conducted an extensive investigatory process over a 350-day period, which entailed 3 public comment hearings, multiple rounds of pre-filed testimony from the parties, several days of field audits and inspections, more than 2,000 interrogatories issued amongst all parties and interveners, 7 days of in-person hearings, submission of 92 late file exhibits, a late filed exhibit hearing, and briefs and reply briefs. The authority issued a proposed final decision in this matter on September 10th, 2025, and provided an opportunity for parties and interveners to file written exceptions and to present oral argument. At oral argument, the authority provided an opportunity for any parties or interveners to comment on whether additional process in the proceeding was warranted. The parties and interveners subsequently had an opportunity to pursue a settlement agreement. The authority was guided by General Statutes Sections 1619 and 1619E, among other relevant statutes, in reviewing UI's rate application and rendering a decision in the proceeding. By law, the company bears the burden of proving that its proposed rates are just and reasonable by a preponderance of the evidence. The authority must deny any portion of the company's request not proven to be just and reasonable to protect the public interest as required by General Statutes Section 16-19E. In this decision, the authority approves an annual revenue requirement of $450,789,348 for the rate year November 1st, 2025 through October 31st, 2026. The company may also recover an additional $413,541 in executive compensation, provided the company achieves certain performance metric targets. The company's revenue requirement also includes an allowed return on equity of 9.45%, but the authority reduces the allowed ROE by an aggregate 20 basis points to 9.25%, subject to certain conditions and timelines to address performance and management issues. The authority also allows a 51% equity component in the company's capital structure. Additionally, the decision, amongst many other determinations, approves approximately $2.602 billion of plant and service and an employee compensation expense to support a staffing level of approximately 670 full-time employees. Thank you for your consideration.
Thank you, Attorney Riley. Is there a motion?
Mr. Chair, move adoption.
I would second.
Thank you. The decision has been regularly moved and seconded. I'll ask for comments from the commissioners, but I'll start with my own. As I explained via correspondence in this docket filed on October 21st, 2025, I've recused myself from this proceeding due to personal substantial participation as both a lawyer and a supervisor for the Office of Consumer Counsel, which has been an active party in this proceeding. And for that reason, I'm going to abstain from today's vote. I think all commissioners have comments, so I'll maybe start with Commissioner Beecher if you have an additional comment.
Thank you, Mr. Chairman. Again, as I joined the authority this morning, I have not had the time necessary to reasonably render a decision on the record in this case. For this reason, I will abstain from today's vote. Thank you.
Thank you. Are there any other further comments from commissioners?
Mr. Chairman. Thank you, Mr. Chairman. Also, welcome to Commissioner Beecher. It's a pleasure to have you here and looking forward to working with you. Chairman Wheel, also thank you very much for your leadership. Short as it has been, we appreciate having you here and look forward to working with you as well. Let me take a quick moment to thank our hardworking PURA colleagues and for their efforts developing this record and this final decision in sometimes very trying circumstances. I would also like to thank Vice Chairman Arconti for his collaboration, inclusion, and extraordinary leadership over the past month on behalf of PURA, and I'm very appreciative. The authority, it should be noted, appreciates all discussions, motion requests, and replies from all of the participants in this docket. The authority, after careful consideration of the proposed final decision, the written exceptions and oral arguments, went into internal deliberations and reanalysis of the record based on those prior events. The PURA also offered a reasonable option and some time for the parties to seek resolution of the application on September 25th for the purpose of exploring the appetite to enter into a settlement. Those efforts terminated with no consensus or resolution. The authority was not idle during that interim and began the task of producing a decision as if no negotiations were taking place, knowing time was of the essence, and consequently have produced what is before us today, the final decision. This commissioner appreciates the good faith efforts of all parties to attempt to dissect, probe, and coax from the voluminous evidence presented to us a decision that is prudent, reasonable, and fair to all those who have appeared before us, and of course to Connecticut's ratepayers. We have conscientiously tried to find a fair balance of needs for rates that provide for a safe, reliable electric distribution system at the least cost we could manage, but that also gets the rates right so that the company can manage its system with an opportunity, not a guarantee, to earn its approved return on equity. This isn't perfect by any means, but I fully believe that it gets the rates right with the revenue that is sufficient, but no more than sufficient to prudently manage the system. Consequently, I shall be in support of this final decision. Thank you, Mr. Chairman.
Thank you, Commissioner Karen. Vice Chairman Arconti, any comment?
Yes, thank you, Mr. Chairman. And I would first like to welcome both you and Commissioner Beecher to the authority. Looking forward to working with you for many years to come. The authority has spent the last year adjudicating docket 241004. The record demonstrates that this final decision was developed with meaningful stakeholder participation. The revenue requirement and rate design are well supported by evidence and consistent with the principles of just and reasonable regulation. Rate cases are never easy. However, I believe this final decision reflects thoughtful analysis supported by the evidence in the record and supports long-term stability. The revenue requirement we are approving today will support continued reliability of essential services and help with addressing aging infrastructure, while striking a balance between affordability and the need for ongoing system improvements. Finally, I thank Commissioner Karen for his comments, for the countless hours working together through deliberation and discussion, which allowed us to reach this final decision today. Also, a huge thank you to authority staff for the long hours that you put in throughout the 350-day proceeding. You are professionals day in and day out. I truly appreciate all the hard work you do every day for the state of Connecticut. I will be supporting the final decision.
Thank you. And hearing no further comments, Mr. Bumping, could you please take the roll?
Vice Chairman Arconti,
Yes.
Commissioner Karen,
Yes.
Thank you. The decision has been adopted, and that brings us to the end of today's regular meeting agenda. We'll adjourn and reconvene next Wednesday, November 5th, 2025 at 9 a.m. via remote teleconference for our next regular meeting. Thank you and have a great day.